Good evening and welcome to our first guest lecture in insurance law. We are very lucky to have with us tonight Julian Burling, who is a general commercial law barrister, and his main areas of specialization are insurance and reinsurance law and regulation. For many years, he worked as counsel at Lloyd's, dealing with all aspects of legal aspects to do with the Lloyd's insurance market, with insurance intermediaries, insurance regulation, and in particular FSMA Part VII transfers. And since then, he's been at Sir Core Chambers, and his clients are insurers, insureds, insurance brokers, Lloyd's managing agents, banks, and UK regulators. He's also a commercial arbitrator and mediator. And most pertinently for tonight's lecture, he has written books on Lloyd's law and practice, and also he's the editor of the research handbook on international insurance law and regulation. So welcome, Julian. And without spending more time on introductions, I hand over to Julian. And so maybe just for by way of housekeeping, we are recording the session. We will be taking a break at some point. And if you have questions, I think the best way is to post them through the chat, and I'll monitor them. And also at the end, there will be some time for Q&A, so you can also then ask them in person. Okay, then I'll hand over to Julian. Thank you very much, and I'm going to mute myself now.
Thank you, Francesca. Well, good evening, everyone. I have to remember to move the slides, because I sometimes forget, even when I'm doing a real lecture. First of all, a reading list. I don't know which of these books are in the library at the CCLS. For the really keen student, Henley and Kemp's pretty good, The Law of Insurance Broking. It's rather expensive, it costs £250. I'm not suggesting you rush out and buy it, but it's worth having a look at it, because it's got a lot of description of what people actually do, especially naughty things. So I recommend it in that sort of way. I wouldn't say it's comprehensive, because it focuses very much on the things that Chris Henley is particularly interested in, but it's worth a read. Now, Bird's Modern Law is a short student's book, but it's got very good summaries and it's pretty up to date in this area. Clark, The Law of Insurance Contracts. Well, I must confess to an interest here, advert here, because I'm one of the contributors to it, and I contribute to these chapters 7, 8, and 9, which are to do with various aspects of insurance intermediaries activities, and also 11.3a, which is the practice of placing business at Lloyd's. And the form of my presentation, the order of subject matter, is based on the content of those chapters. And so if you want to chase up anything I've said, then that is probably the most convenient place to look for it. Colin Ver's Law of Insurance has got a good chapter on insurance intermediaries, and it's reasonably up to date, as you see. Lowry, Rawlings and Merkin is a bit old now, but it's got, again, some good summaries and discussions of principles. It's a student's book. Whether you can still actually buy it, I don't know. McGillivray, again, has a good chapter on intermediaries and it's got a fairly recent edition. I think it's probably had a supplement since 2018. And then finally, but not least, CMS Cameron McKenna have Insurance Broking Practice and the Law, which is a loose leaf publication. It's on the Lloyd's of London Press, or Informer iLaw, so it's very conveniently accessible there. I assume you have that in the library. Well, you must have. So have a look at that if you want to do a sort of, to have a different perspective from my own treatment of the subject. Of course, all these things are online, but the loose leaf ones are particularly helpful online, I think. Now then, insurers, they don't talk about insurance brokers much, or people being intermediaries. What they do is talk about the distribution chain, because really, as far as they're concerned, they're just selling a product, the product that they devise and manufacture and sell to policyholders. And a lot of them aren't too analytical about the process by which this gets done. It's called the distribution chain, but we need, as lawyers, to distinguish between the capacities in which the various people involved in this so-called chain act. The basis of the whole thing is the law of agency. That's the legal framework, and an agent is a person who's given authority by one person, his principal or her principal, to alter that principal's legal position vis-a-vis third parties. Normally, to alter that position as regards contracts made by them on behalf of the principal, but sometimes in other respects. Normally, the agency is conferred by contract, but by no means invariably, as we shall see. Many commercial cases, in fact, I think probably most of the commercial cases I've ever done have involved some sort of slightly disputed point about whether somebody was acting as an agent or had authority to do something or not. So that's how important it is. So now I've got here a sort of spectrum, really, of principals and agents. At the top, we're looking at the paradigm person who's an agent, and only an agent only of the assured or would be assured. Towards the bottom, we've got people who are agents only of the insurers, or insurers aren't their own agents, but they quite often employ people who are. So looking at the top first, one's got this case, re Great Western, and I'm going to read you what Lord Justice Hobhouse said about this. An insurance broker is an agent for the insured or would-be insured. He is not, when acting as an insurance broker, acting as the agent of the insurer in the relevant transaction. If he chooses to act for the insurer, he is ceasing, in at least that respect, to act as a broker and may be in breach of his duties to the insured or would-be insured. It's always important that a broker pay regard to his role in the relevant transaction and the duties which result from his accepting that role. Well, that's really the theme of this evening's lecture. Insurance broking, advice to clients and arranging insurance on their behalf is really a profession. Everybody needs independent and impartial advice on how to fulfill their insurance needs, how to get what they need if it's available. You've got to have somebody who knows the market well to do that, and who's good at negotiating with the other people from whom it's going to be obtained. So it's really a professional job, and it's got to be regarded as such, and people have to be properly trained and educated to do that. It's got to be really taken seriously. When it's well done, it's an interesting and quite a hard job sometimes. So we've got the Lloyd's broker in addition to the insurance broker is at one end of the spectrum. A particular instance of a Lloyd's broker is a broker who has sufficient expertise in the operations of the Lloyd's market, the payment systems, and how business is placed in what used to be a unique way there. So there's a particular class of insurance brokers who are admitted by Lloyd's under the Lloyd's bylaws to place business in the Lloyd's market. They're called Lloyd's brokers, and they were entirely agents in their capacity as Lloyd's brokers, they're regarded as entirely agents of the assured, so much so that in this case, Robinson placed it. A Lloyd's broker was placing some property insurance, fire insurance, on behalf of an hotel, and did the usual disclosure and filled in the forms and so on behalf of the client. There was a fire, and the insurers declined to pay the fire loss because they discovered that the place had been used as a disco in breach of either warranty or it was something relevant that the broker failed to disclose. I forget which. So the claimant said, well, your agent, this Lloyd's broker, who's a Lloyd's broker, had knowledge of this. So this knowledge must be imputed to the insurers. Oh, no, unfortunately, said the Court of Appeal, Lloyd's brokers, they're just Lloyd's brokers, and they're brokers, not agents of Lloyd's or somebody in the Lloyd's market, whatever their title might seem to imply. So, sorry, no cover. But Lloyd's really ought to think about this unfortunate misunderstanding, which arises far too often. But there you are, Lloyd's brokers are basically Lloyd's brokers unless they say that they're something else, in which case they may be a cover holder or whatever, and we'll come on to that. But because they traditionally keep records on behalf of the syndicates as well as the clients, at least they used to until better computer systems, and they keep the accounts, the books of account between the clients and the syndicates, and they receive money on behalf of the clients. They have often been described as, and another reason why they're called servants of the market is because they quite often obtain reinsurance for a syndicate in respect of an insurance, a direct insurance that they're trying to place with the syndicate. And part of the incentive to the syndicate to accept the insurance is the broker will place or may already have provisionally placed reinsurance in respect of that risk. So they're quite often called, traditionally called, even by the courts, the servants of the market. So and they can quite accidentally, if they're not careful, ending up having conflicting fiduciary duties to both sides and both parties of the transaction. So that's insurance brokers, Lloyd's broker, subspecies of insurance brokers. Then we get reinsurance brokers who, again, the paradigm cases, they place reinsurance and collect recoveries on behalf of an insurer who wants to lay off some of their bets. But traditionally speaking, reinsurance brokers keep the accounts between the reinsureds and the reinsurers. The money is nearly always paid through them, often by set-off. There's usually a provision in the reinsurance treaty that says all communications between the reassured and the reinsurer have to go through the broker for two reasons. First of all, it's much more convenient for both sides to the transaction if they're both sending everything through the reinsurance broker, but also the broker can keep tabs on what's going on and help with renewals and placing claims and so on. So three species of broker there. Now we get into a slightly grey area. Somebody who wants to buy commercial insurance may go to a high street broker who may have a bit of knowledge, but they want to do a proper job and explore the relevant market properly. Maybe use a broker who's got more expertise in the particular insurance that's needed. So they will go to another broker, and that broker himself may, for some reason, go to another sort of wholesale broker. Maybe they need to go to a Lloyd's broker to get into the Lloyd's market, or maybe they need to go to a broker abroad, or maybe they need to go to a series of brokers to get cover around. This would happen in big insurance placements. If you're insuring satellite or massive ships or fleet of ships or something, then you may have to have an international placement, and you'll use a team of different brokerage houses to place this risk all around the world. So you've got these placing chains with a series of brokers in, only one of whom at one end is probably in a contractual, in a privilege contract with the person who wants the insurance, and the others are subdelegates of that originating broker. Sometimes, of course, they may be assuming some kind of agency functions on behalf of the insurer. Very often they regard themselves as having only one client, and that's the next broker down in the chain from them. Quite a lot of difficulties have arisen in the past about people in the middle of the chain not appreciating what their fiduciary obligations might be, even if they didn't have a contract, to the would-be assured at the starting end of the chain. And we'll look at that in a bit more detail. Price comparison websites. Well, sometimes you can actually fix your contract through the website. Sometimes they just give you a list of links, and you have to go to follow it up on the website of the insurer that you choose. These have caused a huge amount of confusion as to whether they were actually placing business on behalf of people or accepting business on behalf of somebody else, or indeed both. And the FCA thematic review thought this was a terrible model. And we'll see how they're treated under the relatively new Insurance Distribution Directive. Now we're moving on to people who are manifestly the agents of the insurer as opposed to the assured. Employees of insurers, where obviously they're the agent of the insurer and not the assured. Appointed representatives, they're people who they act as intermediaries for insurance, but they don't need authorization under FSMA because they are people who are appointed by an authorized person, and the authorized person accepts regulatory responsibility for them. In practice, that probably means that they're holding them out as their sub-agent as well to do things on their behalf. So that's appointed representatives. Then you get underwriting agents. There's a lot of this nowadays. Insurers, maybe international insurers, they will appoint local underwriting agents or underwriting agents in professing more expertise in some area of insurance or maybe some affinity group or something that they could ever have. So they appoint underwriting agent to do specialist or localized underwriting acceptance of insurance business on their behalf. There are really two categories of underwriting agents. There are cover holders. These are people who are brokers, but they also act as underwriting agents, often acting as agents for the insurers with whom they're advising their clients to place their business. So that's cover holders because they hold a binding authority and they hold the cover on behalf of the insurer, which they can then write in favor of the people who are their clients. So two hats. Then there are managing general agents or MGAs. They've become relatively common. They are agents only on behalf of the insurers, so no conflict of agency duties there because they've only got one principal. But of course, they do have some duties, which we'll look at a bit later in the talk. Then there are Lloyd's underwriting agents. At Lloyd's, business is accepted, underwritten by natural or artificial persons who are grouped together in syndicates. Sometimes a syndicate has only one person in it, which will be a corporate body. But each syndicate has to have a managing agent, which will manage its business, underwrite the risks, decide whether claims are going to be paid, invest all the syndicate premiums trust funds into which the premiums have to be put, place reinsurance, collect reinsurance recoveries, and so on. That's what Lloyd's underwriting agents do, but they only do what they're doing on behalf of the members of the syndicate. We'll look at one or two cases involving them. Then there are third-party claims administrators. Claims handling by insurers is increasingly outsourced nowadays. It's a specialized thing. It's relatively cheap to engage people to do it for most of it, and it's convenient to do it well out of London, so be done in another part of the country by a separate body. The FCA is always concerned, I think, about outsourcing, so it's got a lot of rules and guidance about it. But third-party claims administrators, they're to be here not confused with claims advisors or whatever who help policyholders make claims and maybe make submissions on their behalf. We'll look at them a bit later. Now, I've mentioned all these different kinds of agents because it's very often the case that a big insurance broking group will have a lot of companies in it that perform some or all of, between them, perform some or all of these roles. So there are there's the team that invent the business that they persuade the insurance company to underwrite. The insurance company relying on the expertise of the broker who's expert in what the market wants. And then they will have maybe a chain of brokers. You may have a Lloyd's broker in the group or somebody who places business in the international markets. And then they may have cover holders to write business on behalf of of some insurance company with which they have a permanent or a semi-permanent relationship. And then they may have high street brokers who are basically supposed to be advising people who want insurance on what's available. But of course, they're part of the same group as the people with whom they're probably going to place it. They're supposed to give impartial advice to their clients on what's available. They've got to tell them whether they've explored the entire market or not, or whether they're just placing it with a few insurers or only one insurer, which of course will be insurers who are in the same corporate group. So these are called integrated business models. All kinds of problems have arisen. So you can have a look at this in the FCA Thematic Report 14.9 and also the Thematic Report 19.2, because the problem still goes on. And we'll have a look at this in a bit more detail later in the lecture. Where am I going? Oh, back, wrong way. That's it. So the sources of the law really, and that in some ways is the most important slide we'll see this evening. The sources of the law are the common law in contract or tort. A lot of these, this has been going on for about 200 years now in this country. These duties are partly derived from market practice, partly from expert evidence given to the court about what happens in the market or is supposed to happen in the market. In addition to the classic common law in the form of Lord Mansfield or somebody like that in Queen's Bench or Common Pleas or Exchequer, you've got the courts of equity, the Chancery Division, and the fiduciary duties that have been imposed on agents by the Court of Chancery, and this is still very much alive nowadays. And then you've got a whole raft of regulatory provisions under FSMA and preceding legislation, now of course heavily influenced, or not just influenced, but actually implementing in the UK EU directives. Most of this will actually survive, I think, certainly for a bit after Brexit, because we invented quite a lot of it in the first place. So if you invented something, then why get rid of it? But there's some of the solvency rules, I think, are likely to change under pressure, and who knows what will happen to the rest. So being an insurance intermediary is, and has been for some time, a regulated activity. There was a thing called the Insurance Brokers Regulation Act 1977, which is really when it started in recent centuries. And this only applied to people who actually wanted to be called insurance brokers. So if they wanted to be an insurance broker, they had to be registered under the Insurance Brokers Registration Act 1977. But if you wanted not to be bothered with being regulated by anybody, then you just didn't call yourself an insurance broker, but did the same thing. Well, in 1986, the then government introduced a much more systematic form of regulation of investment business, and they included investment type insurance in it and life policies. So you get life business intermediation regulated from 1986 onwards, in addition to whatever it was that members of the IBR were expected to comply with. One needs to understand this development because, for a start, it explains what's going on in a lot of the old cases. But it also explains some of the bizarre things, bizarre relics of it that we still have. So then people thought the FSA 1986 wasn't wide enough. And there are lots of different regulators or self-regulators for banking and insurance and so on. So FSMA and the FSA were invented, and they produced improved rules for investment and life business, which went on for about 5 years. And then along came the Insurance Mediation Directive, which was an attempt by the EC to have a relatively uniform regime to assist the development of a European community-wide market in selling insurance or distributing insurance. So they had this directive, which to some extent was influenced by what we had in this country. And to enable the development of the market, it had, across Europe, it had requirements for registration of each broker or each intermediary by its home state competent authority, financial requirements, rather rudimentary ones, but including, importantly, this, requirements protecting claims monies in transmission between the client at one end and the insurer at the other end. So this had to take the form of either some sort of secured bank accounts or a guarantee scheme in case an insurance operation failed, in case an intermediary failed, which happened quite often. There was also a compensation scheme to compensate disappointed clients if brokers had done something incompetent or bad or gone bust. There are rules about information to be given to customers, and in a way, the root of all this, the passport to conduct mediation activities across the EEA. Well, unfortunately, many of the member states didn't really make much effort to implement this stuff properly. They were just very, very late, including some of our close neighbours. And there weren't any real disciplinary or enforcement procedures. So the Commission decided this ought to be radically improved. And eventually we got the Insurance Distribution Directive, which came into force in 2018, that applies to insurers as well as intermediaries. And it makes a lot of rules which had to be transposed into English law about selling insurance, whether you're an insurer or an intermediary. So this insurance distribution chain that comes home in the jargon in this legislation. Now, in this country, the rules for intermediaries in respect of non-investment type business were in the Insurance Conduct of Business source book to begin with. And then there was a revised one, in sort of modernized, streamlined one. The first one was 2005 when the Mediation Directive came into force. The streamlined one, ICOBS, came into force in 2008. The first ICOB gold-plated the IMD terribly and had lots of guidance. Then it was a bit cut down in 2008. But now we have the IDD, and we'll look at that in a bit more detail. One mustn't forget that underneath or on top of all this, depending on one's point of view, is the Financial Ombudsman Service, which accepts claims from claims. It's cheaper than going to court. Small businesses, as well as in fact, medium businesses can claim under the Ombudsman scheme. I think the limit on claims is 350, or the limit on compensation that can be awarded is 355,000, so it's not too bad. And they don't actually apply the general law. They do what they think is appropriate or fair. And it's probably fair to say that most small claims now go to the Financial Ombudsman scheme, so they don't get litigated through the county courts in the way that they used to, in the way that developed our law. So it's a regulated activity under FSMA. As we've seen, the IMD extended regulation to non-investment type insurance contracts. So the scheme of FSMA is that if you want to do various regulated activities, you have to be an authorized person with a Part 4A permission, as it's now called, to carry out that regulated activity. And you look in the regulated activities order to see what the regulated activities are. Well, you have to have permission to carry out a regulated activity in relation to a relevant investment, or rather a relevant activity in relation to a relevant investment. So the regulated activities order tells us that rights under a contract of insurance are a relevant investment, and insurance mediation activities are a group of activities, but excluding activities so far as they relate to large risks situated outside the EA. And I won't go into the details of the boundaries of this, the perimeter, because you just have to look in the order to work that out, or in the FCA guidance. But basically the insurance mediation activities, and they're still called this, are buying or selling investments as an agent, which includes relevant investments in the form of contracts of insurance, arranging or bringing out deals in investments. That's not actually doing the buying or selling as agent, but it's arranging for somebody else to do it. Making arrangements for another person to do it is setting up a system for doing that. Assisting in the administration and performance of insurance contracts is doing things on behalf of the insured and companies that carry out, it says distribution, but it means distribution. Just notice that. It claims handling operations which act only for authorized insurers. They're excluded from this category of regulated activity of assisting in the administration and performance of insurance contracts. And I mentioned them, and we might look at them a bit at the end. Advising on investments, well, if you advise people on what insurance contracts they need to buy, then that's a regulated activity, and you need to be authorized to do that. So suddenly, certainly in 2005, and then even more in 2008, a lot of people who hadn't called themselves insurance brokers suddenly found that they needed to be authorized to do all these kinds of things, and they either stopped it or they got authorized, and then some of them ran out of money. So now an insurance intermediary still is a firm carrying on what's called insurance distribution activities under the IDD, other than an insurer. So these insurance intermediaries and insurers are called insurance distributors. Insurance intermediaries, to core, are regulated by the FCA. They're not big enough to be, from a sort of solvency point of view, to be authorized by the PRA, unlike insurance companies. So the FCA makes its own rules about assets and so on for insurance intermediaries. A very important part of the rules that apply to intermediaries is CAS 5, the client asset rules for insurance intermediaries, and they're these client money rules which require monies in relation to insurance distribution activity to be held in certain kinds of trust accounts. There are various other rules in it too, but that's the most important aspect. And this now applies to reinsurance as well, since the IDD came into force. So now we've got the IDD in force in place of the IMD, because that wasn't being properly implemented and was too weak anyway. So it applies to insurance distribution. I've mentioned what that means. It introduces higher organizational and professional requirements, easier passporting than before, although of course that may go out of the window as far as we're concerned in January. There isn't an agreement, and I think most operations have set up overseas subsidiaries in the European countries that they're interested in if they want to do intermediation business there. There are 3 new general conduct principles introduced by Article 17 of the IDD, which may have been entirely new stuff in some countries, but really they're the same as the duties that agents doing this kind of business would have at common law or in equity. First of all, there's the customer's best interests rule, which was already in COBS and ICOBS. You've got to act in the customer's best interests. We'll look at that in more detail later. Then there's the rule that information given to the client must be clear, fair, and not misleading. We already had that in our own internal regulation. And then there's a rule that intermediaries mustn't be remunerated in a way which conflicts with their duty to comply with the customer's best interests rule. And really implicitly we had that already, but it's now spelled out, and we'll look at that in a bit more detail. There are new information standards, more stringent than just under the old ICOBS, including a new thing called an IPID or IPID, which isn't a creature from outer space like a Driffid. It's just an insurance product information document, which has to be given to consumers, or IPID information has to be given to commercial clients. There are rather limited requirements for the disclosure of the nature and basis of remuneration, which we'll have a look at. There's information on bundling and cross-selling of products, which I'm sure you've experienced, so-called add-ons. And there are now more rigorous requirements about disciplinary and enforcement provisions that member states have to make. So the main lot of rules applying to intermediaries here are ICOBS, originally required. They were copied from the ones for non-investment business. They also implement the Distance Marketing Directive. And they came into force in 2005. In a way, they flesh out the FCA, now the FCA principles for businesses. As I mentioned, they're quite gold-plated in terms of what was in the IMD, but then they were reduced again to the minimum directive requirements in 2008 with a greater reliance on principles and outcomes, as the FCA calls them. Now, this meant that there was less scope for individuals to sue for damages for breach of statutory duty because under Section 138D, an individual, and you have to look in the case law to see what that means, can bring proceedings against an intermediary who's in breach of any of the ICOBS rules, unless there's a provision that there isn't a cause of action for breach of statutory duty under that provision. There is an exclusion from ICOBS following the IMD for large risk cover for commercial customers, large risks outside the EEA or reinsurance. You have to look at the boundaries of that quite carefully to see how it applies in practice. And so ICOBS, as I've mentioned, was amended for the IDD at the beginning of 2018. Here is what is in ICOBS. There are general rules about unfair inducements and the clear, fair and not misleading statements rule and the new customer's best interest rule. So insurance intermediaries really do have to digest this stuff. Then there's a rule about distance communications, a chapter which implements the distance marketing directive. Then there has to be information about firm, its services and remuneration. There's no actual requirement that you have that there be a specific form of contract or indeed any written agreement between the intermediary and the client, because I suppose that's not how the real world works in the case of many consumer insurances. But there is an obligation to identify the client needs and to ascertain quite intrusively in a way what they are, and then advise on what those demands and needs might be. And there's a series of requirements which have been going since the original ICOB about providing information about the products that you're recommending and how suitable they might be or not, and what exclusion clauses they're in, and all that sort of stuff. And I mentioned the new IPIDs that have to be given under their own EU regulation. And then there are some product-specific rules about the politically difficult areas. There are cancellation requirements or other permissions for customers, and some claims handling rules. But it's although these rules do apply and people can be disciplined by the FCA if they don't comply with them, on the whole, the FCA disciplines people for failing to treat customers fairly in a general way, breach of any of the principles of business, or nowadays for failing to produce the treating customers fairly outcomes, which you can read on the FCA website, in particular providing value to the customer. A lot of emphasis now on customer value, applying to insurers as well as intermediaries. Right, so we leave the regulatory framework. So when you're looking at somebody and there's been a row about what they're doing, or when they are thinking themselves about how they ought to be conducting themselves, they need to ask themselves, or we need to ask ourselves, whose agent are they and what's the relevance of this? Well, most obviously, I suppose, at the outset, you've got to consider whether you're under a duty to make sure that your client isn't going to be susceptible to having the contract avoided for, or some other remedy applied for, non-disclosure or misrepresentation. So you have to know whether you're that client's agent to be complying with the pre-contractual disclosure and misrepresentation rules, which are quite complicated now. Knowledge that's relevant will be imputed to a principal's agent. So you need to know whether knowledge that you've got is going to be imputed to your client that you ought to be disclosing, otherwise the contract will be avoided. Or if you're an insurer, you've got to know whether knowledge is going to be imputed to you so that you can't complain if the assured didn't disclose something to you that you're already supposed to know. Obviously, if the agent or the insurer goes bust, then there are pots of money lying around, so one needs to know who was whose agent and who's whose principal and who the money belongs to, or who's under a duty to account for it, etc., etc. Remuneration, who's supposed to be paying the agent, or if not, why not? Then there are confidential reports that brokers quite often get when asked to by insurers, even though they're supposed to be solely the agent of the the assured. So there's quite a lot of case law on that, which we'll look at a bit. There's always the potential for a conflict of interest if you don't know whose agent you are, or even if you do know whose agent you are. And there's a new rule saying in no uncertain terms that you've got to state whether you're representing the customer or acting for an insurer. What about sub-agents of the broker? We've assumed that the broker's been appointed by a client who wants insurance. Quite often we've seen that the broker needs to appoint some placing broker, or maybe get some expertise from somebody else, or at least start off a chain. Well, the general rule in law is delegatus non potestas delegare, which means that there's no implied authority to delegate transaction making to a sub-agent. The only implied authority is to do purely administrative matters. So there needs to be express authority, or maybe ostensible authority, to authorize a sub-agent to do anything, or to create a contractual relationship between the sub-broker and the main and the client. So the client has to authorize the broker to enter into a contract of agency on his behalf with, for example, a placing broker. And this isn't normally what happens. So what about the placing sub-broker who isn't normally in a contractual relationship? Well, they probably won't be entitled to remuneration directly from the assured. They'll have to get it from the producing broker. But they may nevertheless owe a duty of care in tort and also fiduciary duties. Henderson and Merritt, a pretty important case, establishes that if you assume responsibility, you hold yourself out as a professional, having expertise in some area, and you know that somebody's going to rely on that, then you may well be taken to have assumed a duty of care to somebody with whom you're not in a contractual relationship. And in this House of Lords case, very important, there were a lot of managing agents who'd done terribly negligent underwriting at Lloyd's. Some of their names for whom they acted, some of their members of syndicates they had contracts with. Others, those were the so-called indirect names, who had contracts with so-called members agents who had subdelegated their underwriting responsibility to the managing agent and put the names on the syndicate. So there was no privity of contract between the managing agent, Merritt, and these indirect names. Now, I think there were a lot of contracts were written which shouldn't have been, and reinsurances to close were placed which didn't disclose things properly and could be avoided, and so on and so forth. The Merritt agency was being sued, and as far as the indirect names that were concerned, was they said, well, there wasn't a contract, we didn't actually owe you a duty of care. The person who owed you the duty of care was your members agent, so sue him instead. Probably as most of them were bust by then. And in any event, the limitation periods expired. Now in tort, you get a longer limitation period because the cause of action in tort accrues when the damage occurs, whereas the cause of action in contract accrues when there's a breach of contract, which is quite often a lot earlier than the accrual in tort. So if one's talking about a limitation of period of 6 years, then that can make a huge amount of difference. So in this Henderson and Merritt case, the House of Lords held that here was an assumption of responsibility which could give rise to liability in tort if the duty of care was breached. It might be that if there was a collateral contract, then that would limit or qualify somehow the duty of care in tort. But they didn't actually have to decide in that case the extent to which there was any such modification of the duty of care. But it's a moot point in quite a lot of other cases in tort. So one's then got these cases which illustrate the position of sub-agents either way. And I don't want to run out of time. You can ask me about the details later, but the first two here, Prentice, Tonnigan and Leeds, and Pangood and Barclay Brown, were cases where the placing broker, the sub-agent, wasn't held to be in privity of contract with the assured, and therefore certain things followed about reimbursement of whether the whether the producing broker was liable to pay to reimburse the placing broker for premium that had been paid to the insurer, or whether it was the insured who was responsible to do that. That's the first case, and that sort of thing. The other two cases were primarily about whether one insurance broker in a group of broking companies like Aon, who wasn't in direct contractual relationship with the client, nevertheless owed a duty of care because of things they'd said or done or communications they'd shared with a fellow group company's client, and also whether companies in the broker group owed duties to other group companies in the P group who hadn't had a contractual relationship with any Aon company at all. And the judgment in that is quite ranging and very wide-ranging, very instructive, and really worth a read if you want to understand how these things work. And of course, the producing broker will remain liable in contract for the failure of any sub-agent to perform the contractual duties that the producing broker has undertaken to his client to take. Now you see the okeanis for that. You can ask me about it at the end if you really want to. So authority of agents, normally they're reckoned to be three kinds of authority. Obviously, there's express actual authority. Then there's an implied actual authority to do all subordinate acts are necessarily or ordinarily incidental to the exercise of the agent's express authority. Lots of things that, of course, they must have authority to do that. Then there's ostensible authority based on holding out and rules of estoppel. This is the authority ordinarily attaching to the position in which the principal has placed the agent or to the credentials which he has permitted that agent to hold. So it's really a holding out of that person as being in a position in which they are authorized or would normally be authorized to do this kind of thing, regardless of any special limitations that have actually been imposed by the principal as a term of the agency relationship. And we'll look at this in a bit more detail later. So a principal can hold out an agent or permit an agent to hold himself out, but just by standing by when he knows he's doing it, as having an authority that the agent didn't actually possess, or which has been terminated. In this Willis-Faber case is a case in point where Willis-Faber had been appointed to go on placing business when in fact its authority had been terminated, but it was still, as far as the public was concerned, it was still authorized to do that, and it was held to have ostensible authority to have done that. So if there's, we're now looking at the agent of the insured as opposed to the agent of the insurer. We'll come on to the insurer in a moment. The agent of the insured, certainly in commercial arrangements nowadays, you will find a terms of business agreement which sets out what the express actual authority is, and these can run to about 60 pages or so, in my experience, but they quite often forget to put in the one thing that people are actually bickering about at the end of the show. That's express actual authority. Then there's, because there's no actual requirement, except in the Lloyd's market, to have a TOBA with your client. It's just what sensible people do. Implied actual authority, well, what might this be? What some examples of this that the insured might give implied actual authority to do? Well, one is to agree the precise form and content of the policy. There's this case, Zurich and Roebuck, slightly bizarre. People used to have their planes flown to the continent, have their cars flown to the continent in a large aircraft if they were very rich. So here the broker was authorized to get a policy to ensure the transportation of a plane of a car to France. Unfortunately, he arranged for the insurance to cover it going to Paris rather than to Nice, where it was actually going. When this was discovered, the car owner wanted to resile from the very expensive insurance contract, and it was held that the broker had implied actual authority to make this contract a more expensive one, I suppose, maybe, I don't know, but anyway, a useless one, to have it transported to Paris when in fact it was supposed to be going somewhere else. A bit sad, really. Then obviously to disclose or describe matters material to the risk. Also to act in accordance with the custom of a particular market such as Lloyd's, where we know a risk has to be placed. So this might make you subject to a foreign jurisdiction clause that you might not otherwise like, for example. And then there's important case, Cont'd, went to the Court of Appeal about a practice in the Lloyd's market that, and in the London market generally, that brokers would normally be under an obligation to the insurer to disclose to the insurer the assured's placing and accounting records on presenting a claim. It could be some years later. Sometimes the brokers had these records, sometimes they didn't, and if they didn't have them, then the insurer would expect the assured to produce these records. In both cases, this practice bound the broker and the assured to produce the placing and accounting records on demand to the insurers, because it was derived from business necessity, because the brokers customarily held these records and did all the communications between the assured and the Lloyd's market. And I was told once by a broker at Willis that they had 7 miles of shelving at Norwich Airport of broking records. So that's how it worked. Right, so that's actual implied and ostensible authority. You can also have ratification, where somebody has purported to act as a principal on behalf of somebody, but they didn't actually have authority to do what it was they purported to do in pursuance of that authority, but then the principal subsequently adopts it. This happens quite often. It has to happen where you've got a marine policy, for example, marine cargo policy, where the ownership of the goods, and therefore the person who's got an interest in the insurance country, is changing under, for example, a CIF contract, and that's sort of past the parcel from loading on board the vessel until discharge at some terminal at the other end. So you've got to have this ratification so that the person who ultimately ends up being the owner of the goods can ratify the contract that was made on his behalf, or its behalf, more likely, several hands back in the chain of sale transactions. Now, it's got to be understood that there's a principle, so undisclosed principles can't ratify. Normally, there's a rule, except in marine insurance, that you can't ratify once there's been a loss. The idea is that insurance is an insurance against fortuities and not against known events. Of course, sometimes losses really don't become apparent for really quite a long time, and there are dicta, quite strong ones in National Oil Well and Davy, that the rule in marine insurance that you can ratify after a loss should be applied generally anyway. Well, we'll see what happens. Right, insurers, what express actual authority do they have? Or rather, do the agents have? Well, obviously appointed representatives do, because the people who appoint them have taken regulatory responsibility for, and really total responsibility for what they get up to. Managing agents at Lloyd's, well, they have pretty explicit and extensive actual authority to do all the things they normally need to do in running syndicates, and these are all set out in the standard managing agents agreement, which is part of a bundle of compulsory agreements that have to be used in the Lloyd's market under the Lloyd's bylaws. Then cover holders, they will have a binding authority agreement, which tells them, and what they show their clients, if asked, are their authority under as cover holder under the binding authority, what the limits are and the terms they can agree and all that sort of thing. It's a Lloyd's requirement, again, to have a fairly extensive and explicit binding authority agreement. And the Lloyd's Market Association, which is the professional association of the managing agents, has model binding authority agreements that you can look at on their website. It's very informative. If you go on their website, just look up the LMA, standard binding or model binding authorities, you can see what's in one. There are things called limited binding authorities, and it really is limited, and you can look at the interesting case of Callaghan and Thompson to see how limited it is. But I won't go into the details now because we'll run out of time. There's also implied actual authority, as I mentioned in the case of assureds. All these cases, they're a bit fact specific, and things have changed a lot since a lot of the cases were decided with IT and instantaneous communication one sort or another. So these earlier authorities have to be treated with a bit of caution and a bit of common sense. But the existing case law is that local agents have authority to negotiate and obtain proposals for acceptance by an insurance company, but not actually to conclude the contract with the insured, except in the case of interim cover for motor business. Rather curious this, but it's an anomaly. But Lord Diplock, or Lord Justice Diplock as he then was in Stockton Mason, thought that's what all motor insurance brokers did. So that's what the law now is. Local agents have authority to waive breaches of the insured, but maybe not to vary the terms of a contract. The interesting case of Arium British Legion, there was a fisherman who was in the Royal Naval Reserve and during the First World War, and he failed to disclose this when he took out his life insurance, but his wife mentioned this while he was out fishing one day to the local district manager. He came to collect the premiums, and unfortunately later he was killed in a minesweeping operation, and the life company tried to decline cover, and this local manager who'd been collecting the premium in conversation with the wife was held to have waived the breach of the duty of disclosure. Local agents normally have authority to receive premiums, but if we've seen, they've got to put them straight in their insurance broking client money account under CAS 5. What about head offices? Well, non-executive directors have no authority to enter into contracts normally, at least not implied authority on behalf of a company. Executive directors will have whatever authority is usually associated with their particular post. So finance director might. CEO or MD has, according to this old case, implied authority to enter in any contract within the powers of the company. A whole lot of cases giving examples of apparent or ostensible authority, which I mentioned earlier. Now, you can't actually just hold yourself out if you're an agent as having authority to do something. Somehow or other, you've got to be held out by or represented by your principal as having this authority. That's fairly clear from Bousted on agency. So there are various cases on either side of the yes and the no, agency or not. PB Runoff and Woolley, an egregious case, a woman who was on a syndicate which started to make very bad losses. She denied that she'd ever had an underwriting agency agreement. She wasn't a member of the syndicate and wasn't liable to any of the policyholders when bad losses came in. Well, it was established that she had stood by for many years and received the underwriting account of the syndicate and all the profits. So she got pretty short shrift in the court when the Court of Appeal decided that on principles of agency or ostensible authority or estoppel, she was prohibited from denying the agent's authority. Willis, Faber and Joyce, we've seen about the termination of the authority. On the other hand, contrast CX Re and Sun Life, where somebody in the agent's office had authority to agree what the terms of the wording would be, but not authority to enter into the contract based on those wordings. Similarly, at Markle International NSGC, there was binding authority with explicit authority to agree rather limited increases of cover periods, and this limited authority was held to exclude any alleged or general authority to issue wider ones, as the court said, having regard to the reverence accorded to the limits of binding authority in the Lloyd's market. Now, I'm going to stop at this point. Yeah, here we are. This is the first. Now, I've got to deal with this burdensome subject of pre-contractual disclosure or representation or misrepresentation, because lots of things go wrong and have gone wrong we need to consider three periods really for this. First of all is up to the consumer insurance, I can't even remember what DR stands for, Act CIDRA anyway, that's what everybody calls it, 2012. And then the rather stringent law under the Marine Insurance Act and the previous common law, which was codified in the Marine Insurance Act, was modified in respect of consumer insurance in a way which we'll see. And then there was a general revision of the disclosure rules, pre-contractual disclosure rules for consumer for commercial business as well, which came into force in August 2016. But the commercial rules are still different, as you know, from the consumer ones. So there was a duty to disclose every material circumstance which was known to the assured, and the assured was deemed to know every circumstance which in the ordinary course of business that he ought to know. And the knowledge of an agent who had a duty to know and report such facts, the assured, so that they could be brokers or shipping agents or whatever, was to be imputed to the assured. But this didn't apply to a person who was an individual. It was eventually established. And the broker had a direct duty to disclose relevant matters to the insurer, matters which the agent or the broker knew or ought to know, and ought to know every circumstance which in the ordinary course of business they ought to know. Now, the remedy wasn't a remedy by the insurer against the agent. It was a remedy against the agent's principal, i.e. avoidance of the contract. And then the principal had to sue the agent if the agent had any money. One exception to this rather stringent rule was that the agent's own fraud wasn't to be imputed to the assured or to entitle the insurer to avoid the contract. Now, this rather stringent rule was repealed by the Insurance Act with effect from 2016. Now, the insurer's agent, whatever the insurer's agent knew, was only imputed to the insurer where it was within the agent's authority to receive the information. So people often sent their agents out to give policy forms to people and get them to sign them and send them back again. So the courts distinguished between the authority to effect contracts of insurance and to receive information for that purpose, and authority to receive completed proposal forms. And of course, the latter didn't really amount to very much. So you could go out and persuade somebody, some potential customer, to do something and persuade them to complete a proposal form. But your authority could be expressly limited by the insurer purely to receive a completed proposal form. This went badly wrong in the case of News Home, where somebody was helped to complete the proposal form and sign it and so on, but the insurer said, well, I'm not going to accept this. You should have disclosed X, Y, and Z. It matters nothing to me that my agent knew about all this, because actually they had only authority to receive the completed proposal form. That's all it was that bound me. Well, this was put a stop to by CIDRA 2012, and quite right too. And the courts had whittled down the effect of this iniquitous News Home case over the years in the way that we see on this slide here. So the keen among you, or the historians, can look at this to see the process by which News Home got finally kicked out. So there is now an actual requirement for any agent who deals with a potential counterparty to identify whether he's acting as agent or as representing the customer, or is instead acting on behalf of the insurer, or both. Right, so under the Consumer Insurance Disclosure and Representations Act, the consumer has only a duty to take reasonable care not to make a misrepresentation. So there's no duty of disclosure anymore. You mustn't make misrepresentation. So basically, this normally takes the form of answering questions in the proposal form honestly. But nothing in the Act affects the circumstances in which a person is bound by the acts or omissions of that person's agent. So the broker who fills in a proposal form, who makes a misstatement in it in answer to a question, can saddle the his principal, the customer, with the normal remedies for not answering the proposal questions properly. Now, there are some rules set out in Schedule 2 for determining whether the agent through whom an insurance contract made is the agent of the insured or of the insurer. So the agent will be treated as the insurance agent where he's an appointed representative or specifically authorized to collect information or authorized to enter into the contract as an insurer's agent. Pretty obvious, really. In other cases, there's a presumption that the consumer is the insured's agent unless the circumstances appear otherwise. To rebut that presumption, so factors might be an undertaking to give impartial advice, the customer's pays a fee. That would suggest that it's the insured's agent. On the other hand, if the agent is using the insurer's name or selling the insurance under the agent's name, then that suggests that they're the agent of the insurer, or some sort of cover holder or something. Under the Insurance Act, and this is doesn't apply to consumers, it applies to non-consumers, commercial contracts, there's a duty on the insured to make a fair presentation of the risk. So actually most people think it's pretty much the same as the old duty of disclosure dressed up in modern language, the language that the broker's already used. So the disclosure of every material circumstance the insured knows or ought to know, or failing that disclosure which gives sufficient information to put a prudent insurer on inquiry. So failure to make that presentation enables the insurer to exercise various remedies which aren't limited to avoidance. There's no duty to disclose matters that the insurer knows or ought to know, and so Section 5 tells you what matters the insurer knows or ought to know, which includes that his agent knows it. And Section 4 tells you what matters the insured knows or ought to know because the insured's agent knows it. We'll look at those in a moment. And specifically, references to things done by or in relation to the insured or the insurer include references to their agents. So there's a duty on the insured to make a fair presentation of the risk in a reasonably clear and accessible manner. And every material representation as to fact must be substantially correct, and if it's as to expectation or belief, it has to be in good faith. So if a broker does all this and fails to do these things, or he purports to fill in the proposal form or make a presentation to the insurer, and fails to do these things, then the insured is stuck with it. We'll have to sue the broker, as we shall see in due course. So here are the rules for determining what an insured knows or ought to know. Only what is known to self or individuals responsible for the insured's insurance. This is an individual insured, but a non-individual, that's a company or maybe a partnership, is deemed to know only what is known to the individuals who are part of the senior management or responsible for the insured's insurance, which obviously will include their insurance broker or risk manager or whatever. But an insured is not to be taken to know confidential information known by an individual, such as a broker, who's acquired it through a business relationship with another person not connected with that insurance contract. And the insured's got to make a reasonable search of the information available and give it to the broker. Maybe the broker has to make a reasonable search of the information that the broker has available to him or her. So here are the rules for determining what an insurer knows or ought to know for the purpose of the Insurance Act 2015. Again, deemed knowledge only of individuals who participate in the underwriting decision, whether or on what terms to take the risk. And the insurer ought to know what any employee or agent knows and ought reasonably have passed on to the insurer. And information held by insurer and readily available to the individuals who participating in the decision whether or on what terms to take the risk. So if you made a claim 5 years ago, and that's probably in their record somewhere in some computer storage thing in China or somewhere on the air, then that probably wouldn't fall within these things. So you have to, if you're insured, probably better make sure that you're disclosing previous claims you've made against the same insurer to be on the safe side. Okay, so that's the end of disclosure. You have to look through that stuff carefully, but maybe you know it already. It's part of your general insurance law course. Now then, the rights and the duties between the insured and the agent of the insured. These are a mixture of contract and tort and equity and statute. So as we've seen, the intermediaries can be concurrently liable in contract and tort, often which much the same result, but there may be different limitation periods. And this following Henderson and Merritt, this was applied in a case called Equitas and Walsham about Lloyd's brokers, which we'll have a look at in a little while under slide 42, if you're following the slide numbers. Actually, this rule, there's a long established rule that brokers could be liable in tort as well as contract. And all the earlier authorities than Henderson and Merritt, which of course wasn't applying to brokers, it was applying to underwriting agents at law. So that line of authorities relating to brokers is actually set out in the Superhells case, which is on slide 29, and we can have a look at it later very briefly. So there are different limitation periods for contract and tort. The contract of agency may, of course, delimit the scope of the duty of care actionable in tort and of the scope of any fiduciary duties in equity. So we'll come on to look at that. The common law duties may be informed or limited by analogy with its ICOBS or ICOBS. And then there are these cases here, Dunlop, Haywards and Varvan, and Harrison and Blackhorse. Now, Harrison and Blackhorse has to be treated with a bit of caution because they said not only did the absence of anything in ICOBS about disclosing the amount of remuneration received restrict their duty at common law or in equity to disclose it. This was a customer. But also, by analogy with this failure of the legislators to make a rule about it, also for the purposes of the Consumer Credit Act, failure to disclose this vast amount of brokerage and commission that people were getting wouldn't vitiate a credit contract, consumer credit contract, on the ground that it was an unfair relationship. To put it in other words, if the legislators hadn't thought to require disclosure of exorbitant commissions, then they didn't think it was an unfair, under one lot of legislation, they didn't think it would constitute an unfair relationship under another one. Otherwise, they would have required the disclosure of that. Anyway, the Supreme Court kicked that out, and quite right too. Now, a breach of any rule in COBS or ICOBS can give rise to an action for damages for breach of statutory duty at the suit of a private person. And if you look in Clark in Chapter 9, you'll find out how a private person is defined. This is under Section 138, unless otherwise provided. In the case of somebody who's not a private person, actually, no, forget that. There isn't a statutory duty in the case of a non-private person. Right, we're going on to the next one. So that's how tort liability might be characterized or instantiated in terms of what is in or not is in what is in ICOBS or not. So the general rule is where there's purely economic loss. Well, the general rule is the intermediary has to owe a duty of care, and in this case there has to be an assumption of responsibility to find tort causing purely economic loss. The intermediary has to breach that duty, and the breach has to cause the claimant loss. There are lots of cases about whether these individual elements have been made out, but you can have damages in tort for purely economic loss only where there's a negligent misstatement or the negligent performance of services by a qualified person. And essentially that's what Merit decided, but it's articulated in more widely in the case of Customs and Excise Commissioners and Barclays. So there'll be a liability, or there may be a liability to third parties where their reliance on a broker, for example, is foreseeable. So here in Punjab National Bank in Bourneville, the broker placed insurance on behalf of, I think it was a ship or cargo owner, I forget which, but this was taken out at the insistence of the mortgagee, and the broker knew this, so was held liable to the bank for, I think he was making a non-disclosure, but anyway, jeopardizing the validity of the insurance. Similarly, as we've seen in, as I mentioned, in BP and Aon, case there about groups of broking companies on the one side and groups of oil extraction companies on the other side. The broking companies all knew that all the companies on the BP drilling operation in Texas and also in London and so on would be relying on what various activities of non-contractual activities of the various AM companies in London and in the chain to that company in London would be getting up to. So they were held liable to the various BP companies. Dunlop, Haywards and Erinaceous is the case about a commercial estate agent who they did do property dispositions, but they also did property valuation, commercial property valuation activities, which is a pretty hazardous property in a versatile property market. And the courts paid attention to the rules about providing information and so on about the risk to the client. Well, you can read that case to find out what happened, but the reliance was foreseeable because the placing broker at Lloyd's was in direct contact with the well, at least it could have been liable and was held not to be. In fact, the placing broker was in direct contact and communications with the ultimate client. Against that are Pangood and Barclay Brown, which I think I mentioned earlier, and Ilden Volnert and April Grange. It's about a yacht called the Galatea, where the if not asked, the placing broker at Lloyd's wasn't under any duty at all to volunteer advice on how you made a claim or what information or within what time period you had to make claims under this particular policy. Didn't have to advise on this if you weren't asked, which they weren't. But it's an interesting case to read, together with the Aon case, on how these things work and how insurance is placed, and then how claims are made when something goes wrong in the Lloyd's or really in the London market. Now then, what about rights? We've looked at tort. What about rights in contract? Well, first of all, is there a contract at all? If you ask a broker to advise you on some insurance, but actually you don't get along with his recommendation, unless he's charged a fee, was there a contract in the first place? Was there any consideration? Was it opportunity to earn a commission if the client decided to take up the policy proposed? Well, of course, they're not obliged to take up a policy proposed, so there may never be a contract at all. It's all very fact specific. Big commercial contract insurance arrangements, there may be a commercial engagement. You may, quite often people have to pay fees for this nowadays, irrespective of any commission that might ultimately be earned. In the London insurance market, terms of business agreements are now normal, and there will be fees probably, but there's no legal requirement, not even in ICOBS, to have a TOBA. But there is, however, in ICOBS, a duty to explain the status of the intermediary, what services they're going to provide and what fees they will charge. In contract, if there is a contract, there's an implied term that in placement, the broker has a duty to ascertain the client's needs, use reasonable skill and care to obtain the cover requested, and if they can't get the cover requested, to tell the client and obtain alternative instructions. And the big case on that is Ewell and Bland, which actually is a reinsurance case, the Superhulls cover case, jolly good read again. But it's also in ICOBS 5.2 and in 6. That's about the information. Now, after placement, are there any continuing duties? Well, there are if people undertake them or go on interfering with the cover after it's been placed. It's happened, I think, in BP and Aon, but it's certainly some other cases if they go on administering the contract and then they notice that something's going wrong. Maybe there was a previous non-disclosure or there's some duty to inform an alteration of risks or something like that, then there will be a liability there. Grace and Leslie in Godwin Financial Services was a non-Lloyd's brokers case. It was held implied that they had a duty to assist the client in presenting claims, if so requested, and to maintain records. In that case, for well over 20 years, this was long-tail business. Big, I think there are asbestos claims in. Clients came in. Of course, the syndicates in question haven't got the faintest idea what the risks were, whether they'd even written them. They were sued, and Leslie and Godwin Financial Services were held liable for not making or retaining sufficient records, enabling them to enabling the syndicate to know what to do about the claim. And of course, quite often the claim will be in an American court, so you're just over a barrel there. Non-Lloyd's brokers, well, slightly debatable whether they have this duty. What about a non-Lloyd's broker who's running off business? Well, some interesting cases coming up on that. Lloyd's and brokers, this Grace and Leslie and Godwin Financial Services was relied on in this Equitas and Walsham case. Equitas and Walsham was a case where, in fact, Equitas which was the running off all the pre-1993 business in the Lloyd's market, and eventually was the statutory transferee of it, was running off all those syndicates' business, and it took over the relationship with Walsham Brothers reinsurance brokers, who had been supposed to be collecting the reinsurance recoveries on behalf of all those syndicates in the Lloyd's market. Walsham made lots of collections, but they hung on to the money for a very long time. And what a lot of brokers used to do, after they've had the money for 6 years, they just say, well, the Limitation Act now applies, so we'll do a credit write back, and we won't hold it in our books of record as payable to the reinsured syndicates anymore. Well, the court didn't think much of that. Again, Equitas and Walsham is a jolly good case on brokers' duties. But in that case, Mr. Justice Males, as he then was, held that there was an implied term that, irrespective of these common law things, under the Suppliers, Goods and Services Act, there's an implied term that the broker will exercise reasonable skill and care in performing the services that they're supposed to be providing. So that's tort, contract. What about equity? Well, there's a fiduciary duty to act bona fide in what the intermediary believes to be in the best interest of the client. And this has now been expressed in ICOBS in this country and also in the IDD as a matter of EU directive as the customer's best interest rule. And we've had this rule for ages applying to insurance brokers in this country. Interestingly now, it expressly applies to each intermediary in the placing chain. So intermediaries before might have tried to argue, well, I didn't have a contract, or I didn't really have a fiduciary relationship with the assured because they're too far down the long end of a chain. I didn't really know about them. I never made contact with them. I never made any representations to them or anything like that. Well, now at least the duty to act in the customer's best interest applies up and down the chain where ICOBS applies. And there's a statutory right of a private person to damages where that rule is breached. And you can see the FCA principles, or FSA principles as they were, which preceded this importation of the customer's best interest rule under the IDD. So customer's best interest rule, there's another duty rule, fiduciary duty, stated in the Principle 8, FSA now, FCA Principle 8, a firm must manage conflicts of interest fairly. We've seen how they can arise where conflicts of interest as between, or conflicts of duties as between two different principles, but also a conflict of duty and interest where one has a duty to one's client, but an interest in getting them the maximum amount of commission out of the insurers. So this might induce one to choose or recommend the insurer who pays the highest rate of commission, or indeed who charges the highest premium, which is manifestly not in the interests of the policyholder. So there's an obligation to identify, record, and manage and disclose conflicts of interest. And there's also a general principle now, which there wasn't earlier, that insurance distributors must not be remunerated or remunerate or assess the performance of their employees in a way that conflicts with their duty to comply with the customer's best interest rule. But there's no right in either of these CISC 10 or CISC 19 rules to damages if that statutory duty is breached. I think it's thought that they were too loosely phrased for it to be fair to have a breach of damages for breach of statutory duty for that. Interestingly, the FC now considers that excessive remuneration, and this is as a result of its thematic reviews into various aspects of the placing chain in the insurance markets, the small and medium enterprise insurance market, but also the individual ones. They consider that excessive remuneration will itself be a breach of the customer's best interest. And that's expressly put in finalised guidance 19.5 that you can find on their website. I haven't given the link to it, but finalised guidance 19.5, have a look at it. And obviously before we had ICOBS 2.31G, a firm, this is just guidance, to what extent would the courts pay attention to it as ICOBS guidance, I don't know, must consider whether soliciting or accepting inducements or offering them would conflict with the customer's best interest. Well, pretty obvious, the Court of Equity would say. Now, there were a lot of appalling practices in New York in the late, well, actually for a very long time, but it came to a head in about 2008, 2010. People took contingent commissions. So that was, they gave commissions to the brokers on the maximum, on the total amount of business a broker brought to them each year. And these are insurers. There's price rigging. Brokers would put in false quotes, which was so ridiculously high that, or rather they'd get insurers to make such ridiculously high quotes that nobody would ever accept them. They took it in turns to do this. So they parceled out the market between them all. And some people got fined very heavily and possibly even sent to prison in some cases because of this. I'm sorry to say that the New York Insurance Department has rather backtracked on this, but I don't think the FCA will have here. Anyway, you can look at that in a bit more detail in a moment. So that was, I characterize that as no conflict of duty and interest. Here, there must be no conflict of duty between two principles you've accidentally found yourself or deliberately found yourself with. Obviously, cover holders, they're underwriting risks, but they're presenting and they may be determining claims on behalf of the insurers. Well, what on earth are they going to do? One reason why insurers might have separate claims departments who will handle all the claims stuff, but cover holders are still presenting claims on behalf of clients who were their clients in their capacity as brokers. So they've got to sort that out. And then, of course, quite often, as we've seen, brokers will have historically commissioned, they get a claim, they present it to the underwriters tell us, go away and get us a loss report, or if it's an American claim, maybe a report from American attorneys telling us what our exposure is. They went off and did this. They held them confidentially from their clients. There was a frightful row about this periodically in 2 cases that went to the commercial court. So the reports were held to have been got in breach of their fiduciary duty to their clients. Nevertheless, the courts wouldn't order the disclosure to their clients of these confidential reports, which were confidential to underwriters only. So lots of egg on face all around. Well, this isn't allowed now. The TOBAs don't permit it for Lloyd's brokers that they have to have with underwriting agents. They can only get such reports on behalf of underwriters if they're allowed to disclose them to their clients. That's what the TOBA says. So that's what the position between Lloyd's brokers and the managing agent for the syndicate is. What about placing documentation? Well, I mentioned that. That can be disclosed because the insurers have already seen it anyway, so it's not unreasonable for there to be a practice explicitly sanctioned by the TOBA for the placing documentation that the broker has or can get to be disclosed by the broker to the insurer for once more. And I've mentioned twice already this requirement under ICOBS that a broker or an intermediary has to inform the customer whether he's representing the customer or acting for on behalf of the insurer. And the LMA Model Binding Authority Agreement requires, and did before the IDD came in, it requires a Lloyd's cover holder to notify the prospective insured of any capacity in which it acts for underwriters. So, no secret profits. Intermediaries are usually remunerated by a commission paid by insurers. Everybody knows that, although there's an increased use of fee agreements for commercial clients. So these commissions normally paid by insurers. Well, the normal commissions are allowed by usage or implied agreement. Lots of 19th century cases on this, but not abnormal commissions. They've got to be disclosed. So a lot of debate about what is a reasonable commission. Great Western Commission, Cunliffe is a case in which there were normal and abnormal commissions. They got away with not disclosing the abnormal ones because, well, actually they did disclose them, and the insured, or rather the reinsured, didn't mind. But it's a terrible precedent that's been relied on ever since. Now, I think it's not going to be relied on much longer. What the courts say now, certainly in well, the general rule is that you can have reasonable commission or the normal amount, but not what is excessive unless the amount is disclosed. And the courts have now applied this pretty rigorously in a line of cases, I suppose starting with Macmillan and Norton. They just take the view that if somebody's charging 70% or something, then that's, which they do in these consumer contracts, quite often associated with taking out mortgages. So you get mortgage linked with the sale of an insurance or maybe a life policy to help you pay the installments due under the mortgage. The effect of that will be that if there's excessive commission, it will be held to be unreasonable. If it wasn't disclosed, then the position will be that the commission can be recovered, but also if there's been a total non-disclosure that it was being paid, or that there wasn't even any possibility of it being paid, then the mortgage itself can be rescinded by the court as a discretionary measure in equity. And there have been quite a lot of cases on that, but I won't weary you with that this evening. You can look it up in Chapter 9 of Clark if you want to. But I mentioned Plevin and Paragon Personal Finance already, and the relationship between unreasonable commission and the unfair credit relationship under the Consumer Credit Act. Right. Contingent commissions, I've mentioned that. Another way of getting extra money out of the insurers without disclosing it to the clients is calling it work transfer fees. And the FSA and then the FCA has had a fair amount to say about this. Work transfer is when the broker does quite a lot of administration of the insurance that would normally be done by or on behalf of the insurer and charges the insurer a fee for it. Well, I think they take the view that these got to be disclosed now if they're not part of a normal commission to normal rate. I mentioned all these documents in ICOBS and various documents that the industry bodies have put out to try and mollify the regulators and the press and so on, the BILA document. But then the regulators have got increasingly hawkish on this, and so have the rules, and especially under IDD, and so is the FCA under the customer value rules. But there is still no rule that you have to disclose the amount of your commission to consumers. Only has to be disclosed to commercial customers and then only on request under ICOBS. Now, the general law is, of course, that a private customer an individual can require disclosure of commission, and it's got to be disclosed to them if they request it. But generally speaking, they're not informed of that right, so they don't ask. And of course, most of them are only interested in the overall amount of what they're paying. But if they knew that 70% commission was being charged, then they might have a different view of it. So I think the law is unsatisfactory in that relationship, in that respect. We'll see what happens. It's interesting to note that when the first draft of the IDD was produced by the European Commission, they did suggest that the amount of commission should be required to be disclosed in all circumstances. But the UK government unfortunately took the view that it was just too cumbersome and people wouldn't really want to know, and it's too difficult to explain. So we won't. We would recommend that the IDD didn't involve such quite a hawkish rule, at least for consumers, and so it doesn't. It just requires the amount, the fact that there is a discussion is a commission, but not the amount of it. I suppose there's an implication that you can ask. I mentioned the confusion caused by these developing integrated business models, so you can track all this. Of course, technically speaking, if somebody offers an amount of money to an agent as an inducement for that agent to place business with them, without either themselves or the agent telling the principal that that money's been paid, then it's what's technically called a bribe. And if there is a bribe, then the transaction will be rescinded by the courts. Of course, the amount of the money, the amount of the bribe will have to be disgorged by the agent or even the third party, the rules of equity. It's held on trust by them, under this case FHR European Ventures. So the remedies in equity are quite powerful, but this is always subject to this stuff about whether the commission is normal and reasonable or not. And if it is, then it can be justified. And there's Lloyd's guidance on this, which is worth a read on the application of the Bribery Act. These bulletins are on the Lloyd's website. You just go into Market Bulletins on the Lloyd's website and check these bulletin numbers. Right, so apart from not taking bribes and so on, what are the duties of an insured's agent? Well, to identify and advise its clients about the type of cover which the client needs. In doing so, match as precisely as possible the risk exposures which have been identified within the client's business with the coverage available, and having identified the client's needs, arrange insurance cover which clearly meets those requirements. And this corresponds pretty much to the enhanced demands and needs requirements of ICOBS that are now there. But it's a very good common law statement of what the broker's duty is. So the broker may need to explore the nature of the client's business. I'm not going to go into the facts of these because we'll run out of time otherwise, and you might have a question or so at the end. The client should not be exposed to the risk of legal disputes with the insurer, because legal disputes with the insurer are always a chancy business, and quite often there's going to be some sort of settlement anyway, rather than fighting it to a bitter end. So there's a downside to compromising a disputed claim with the insurer. So if that happens, then the client might well end up suing the broker for the difference between the settlement amount and the amount that they could have recovered from the insurer if there hadn't been a non-disclosure or alleged non-disclosure or whatever. So two quite interesting cases there. Information. A firm must take reasonable steps to ensure a customer is given appropriate information about a policy in good time and in a comprehensible form, so that the customer can make an informed decision about the arrangements proposed. Well, in the Do Not Pay Was Bargain case, the cover that was actually bought by mistake only covered the estate agent's transaction and not its property valuation activities, and of course big claims in for misvaluation of properties, which wasn't covered by the insurance that had actually been bought, and it was the producing broker's fault because they hadn't taken reasonable steps to ensure that the customer was given the appropriate information about that actual policy which was going to be bought. So if the broker is unable to obtain precisely the cover sought, does he have a discretion to obtain an alternative? Well, sometimes yes, sometimes no. Depends how alternative. I think the best thing is to just check with the client. Need to explain to the customer where less favourable terms are obtained than the ones which were asked for or represented as being available. Pretty obvious if you think about it. Here in GNER against JLT, John and Lloyd Thompson, there was a narrower faulty workmanship exclusion, and the broker was held liable for the hole in the cover that had been expected. Mustn't give warranties or make representations on behalf of the customer based on ambiguous information. If it's ambiguous, then go back and check. Fisk and Brian Hawthorne. I think that was another Disco case. Solvency of the insurer, pretty important. Insurers don't go bust quite so often now as they used to. I think partly because of Solvency too and much higher capital requirements. But there must be no reason for supposing that the insurer is not a responsible and solvent person. So the broker must check. And there's now this quite useful FCA insurance brokers due diligence on the insurance guide on their website. Check their SFCR, their Solvency financial condition report. If they're a Solvency II insurer, look in the FCA and Ombudsman complaints databases. Look at their audited accounts in Companies House. Look at the BILA litmus test if they're a foreign insurer. Look on the FCA register to see what's been going on and who the people are who are running it. If they're not a licensed insurer, you may not be able to recover because in the old days, the policy would have been unenforceable. Of course, if they're not a licensed insurer, they may not be very well regulated by the foreign regulator, so they might become insolvent when you didn't expect it. So that's a thing that's got to be checked. Where are they licensed? What do you think of if they're not UK, what do you think of the licensing regime, particularly if it's not an EEA Solvency II insurer? Policy interpretation, pretty obvious. Explain unusual exclusions or conditions. Grant Goulby had a case about a lot of space heaters that had to be improved and weren't, and the place burnt down. The intermediary, pretty obvious this, but check the policy to make sure it's what they thought they were buying on behalf of their client. They must disclose to the insurer what it is that the client is duty bound to disclose to the insurer to make a fair presentation, or if it's a consumer insurance, to answer the questions accurately that are in the proposal form. Ilvolnert and April Grange, there was an egregious failure. That's about the yacht Galatea. Egregious failure to disclose the basis on which the value of the yacht had been provided to the insurers. Good grief, that case, have a look at it. You may need to investigate the client's business in some detail and their record to see if they've had any financial difficulties in the past or they understood what they were doing. You've got to find out what matters need to be disclosed in answer to the questions or disclosed under the general fair presentation rule. What about post-placement duties? Well, I mentioned that. If a broker becomes aware of information detrimental to their cover, well, they may have to tell either their client or tell the insurer. This is where there's some sort of continuing relationship, which there was in those 3 cases mentioned there. There's no duty at common law to remind the client that a renewal might be desirable shortly, but ICOBS 616 requires that. So have a look at that and see what it says. What about remuneration? So those are the duties of the. So I missed this. Yeah. You've got to keep sufficient records and provide sufficient information and documents to inform a client about what monies have been received on the client's behalf. You've got to disclose those records if the client wants them, even where the records are mixed up inextricably with the records relating to other clients. Equitas and Horace Hellman and some subsequent cases established that. And of course, brokers do net accounting. So their records about what money's been received and what money's not been received, or so on and so on, they're bound to involve some degree of looking at other people's records in the mixture of the London market brokers' accounts. Monies have to be paid reasonably promptly once they've been received. They've got to be collected reasonably energetically, and when they've been received, they've got to be accounted for and paid over reasonably promptly. And see that Equitas and Walsh and Brothers case that I mentioned earlier. The FCA client money rules now require monies received by the intermediary to be held on a Cas 5 statutory trust. Premiums coming towards the insurer from the client may be held on a risk transfer basis so that the client is no longer exposed for any claim by the insurer for non-repayment, for non-payment of the premium in a case where the agent goes bust, as I'm afraid sometimes happens. I mentioned the duty to require retention of records for claims. In fact, they used to rule at Lloyd's for a period between 1988 and 2000 was that the brokers had to keep the claims records for 80 years, but they scrapped their rules about claims records retention in 2000. Remuneration, well, we've seen this already, a reasonable sum, except where it's implied that the broker will receive commission from the insurer instead, which is what normal happens. The broker may have a right to damages for the loss of opportunity to earn a commission if, in some cases, depends what was in the TOBA or what representations were made about what the intentions of the client were. Inconclusive if the broker can sue the reinsurer where the reinsured hasn't paid the gross premium to the broker, so has left some of it out. Have a look at the cases if you're interested. This is for the connoisseur, and I'll deal with it in the reinsurance brokering lecture. Reimbursement and indemnity where a broker's liable. If the broker's liable under the Reinsurance Act in some reinsurance case to the insurer for the premium, then he's entitled to be reimbursed or indemnified, or indeed where they've paid it out of their own money at the insured's request on behalf of the insured, and irrespective of whether they were personally liable for it to the assured under the Reinsurance Act, then they're entitled to be indemnified, and they have a lien on the policy and on any losses or return premiums collected for the amounts they've paid out, to which they're respect to which they're entitled to be indemnified. Well, that's that.
Thank you so very much, Julian, for this very, very comprehensive presentation. And for me, it's really a reminder that the law that relates to insurance intermediaries is not just an add-on to insurance contract law. It's really subject in its own right. And there's so many aspects to it, from contract law, agency law, tort and insurance regulation, etc., which makes this particular area so fascinating and complicated. Then, okay, well, thank you very, very much. And it was a great honor to have you with us. And it was a great presentation. And I'm sure everyone found it really helpful for their modules in insurance law and insurance regulation. So thank you very much.
Okay, a pleasure. Thank you.
Bye-bye, Julian.
Bye then. Bye. Good night.